There we go. Welcome, everyone. My name is Patricia Maloney. I am the president of Texas Tech's Phi Beta Kappa chapter. Phi Beta Kappa is the oldest and most prestigious honor society in America. Here at Texas Tech, we annually induct about 5% or so of the junior and senior class, based not just on their GPA, but also on the breadth of their studies. Is the student going for a true liberal arts education? Texas Tech thinks so highly of Phi Beta Kappa that the university has agreed to pay for lifetime memberships for all inducted students, as well as lovely gold jewelry, which am I wearing today? Yeah, I'm wearing today. I'll put our website in the chat, but if you'd like more information, you can email pbk@ttu.edu. I am so very pleased to be able to introduce Professor Adam Winkler to you as our 2021 visiting scholar. Professor Winkler is the Connell Professor of Law at UCLA's School of Law. He's a specialist in American constitutional law, the Supreme Court, and gun policy. His scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments, and he is one of the 20 most cited law professors in judicial opinions today. His talk today is titled "The Second Amendment at the Crossroads." Since the Newtown Massacre in 2012, which I happened to be down the road from when that occurred, that was quite the traumatic day. The gun safety reform movement has been reinvigorated and now even outspends the NRA in some elections. The Biden administration is determined to enact meaningful reforms, yet a Supreme Court with 3 new justices is likely to expand Second Amendment protections. Professor Winkler, I am on tenterhooks to learn more, so please take us away.
Well, thank you so very much. Let me thank Professor Maloney and to the Phi Beta Kappa Society for inviting me to be with you today. And of course, thank you to all the participants who are logging in. It's just great to be with you today. Only regret is that we're not doing this in person and that I'm not able to meet you all, shake hands, and get to know you a little bit more informally. So, but my subject today for this keynote is guns and the Second Amendment to the Constitution. In the United States, we're at a crossroads on guns. On the one hand, the gun safety reform movement has been significantly reinvigorated over the past decade. There's been a torrent of mass shootings from Newtown in 2012 to Parkland in 2018. And this has mobilized grassroots activists like Moms Demand Action to be more engaged than ever. We've also seen the rise of wealthy new pro-reform organizations such as Everytown for Gun Safety and Gabrielle Giffords Super PAC. And these organizations have spent millions on elections, even on occasion outspending the NRA. For decades, nearly all the money going into elections on the subject of gun policy came from the gun rights side. But in the 2018 midterms, gun safety reform advocates spent more on federal elections than the NRA. And the same is true for some recent state elections, such as a ballot measure campaign in Washington state on mandatory background checks. The Democratic Party has also taken up the gun safety reform cause. In the 1990s and early 2000s, Democrats mostly avoided talking about gun safety because it was seen as a losing issue on election day. And this was especially so in closely divided swing states that Democrats needed to win to secure a majority. I remember back in 2008 when Barack Obama was running for president and I was writing my book on the right to bear arms, Gunfight, the battle over the right to bear arms in America. I remember that Barack Obama barely mentioned guns in his presidential race. And when he did, he was almost certain every time to mention his support for an individual right to bear arms. Now, after the Newtown shooting in 2012, right after he was reelected, President Obama made gun safety reform a priority. And although he was not successful in winning any significant new federal reforms, we saw in the 2020 race for the Democratic presidential nomination, each of the candidates propose expansive gun reforms, each one more aggressive than the next. And the new invigorated strength of the gun safety movement has resulted in a number of states passing laws to close what gun safety advocates call the loopholes in current federal law. These include laws requiring universal background checks, laws restricting military-style rifles, and bans on high-capacity magazines that can hold over a certain number of rounds of ammunition. Now, of course, the gun rights movement in America is and has been one of the most powerful political forces of the last half century. And it really remains strong in America, despite the newly reinvigorated gun safety reform movement. And gun rights advocates defeated President Obama's proposal for universal background checks and restrictions on military-style rifles. And like I say, they remain, among the most powerful political forces in America. Moreover, the gun rights movement has a significant new ally, I wish to suggest, and that's the Supreme Court of the United States. Any legislative victory that's obtained by the gun safety movement will inevitably have to survive a court challenge. And the Supreme Court appears ready to sort of significantly strengthen gun rights and make it harder to enact gun reform. Next month, the Supreme Court is going to hear an important Second Amendment case that could cast into doubt much of the newly energized gun safety reform movement's agenda. And in my talk today, I'd like to discuss that big case that's coming down the pike in the Supreme Court and describe sort of think about a little bit about the implications that case might have for the Second Amendment and for gun reform more generally. So let me start with a little bit of background, if I can, right? The Second Amendment provides, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. The sentence structure is confusing, and it's almost as if James Madison, the author of the Second Amendment, had just discovered this wonderful new thing called the comma and wanted to put it in there as many times as possible. And while there's been much debate in recent years about whether the Second Amendment guarantees an individual right or just something that protects state militias, to the framers, these differences may not have mattered very much. The founding generation had no standing army. They thought, based on their experience as English people and with English history, that a standing army would inevitably be a force for tyranny, that the monarch, or in our case, the president, could use the standing army to deny people their liberties. National defense relied instead on state militias composed of ordinary citizens who would bring out their own guns when called to serve. We all remember from grade school hearing about the Minutemen, right? The people during the Revolutionary War who'd go home, grab their guns, and be ready to fight in an instant. And so while the primary purpose of the framers was certainly to preserve state militias, it may be that the way they did that was to guarantee individuals the right to have their own arms. Now, although the Second Amendment was added to the Constitution all the way back in 1791, it wasn't until 2008 that the Supreme Court, for the first time, clearly held that the amendment guaranteed an individual right to bear arms and struck down a gun control law. That 2008 case was called District of Columbia against Heller, and the court struck down a law in Washington, D.C. that prohibited residents from owning handguns. They were also, residents were allowed to own long guns like shotguns or rifles, but under the law, they had to keep them locked or disassembled, except for certain recreational purposes. A court ruling in Washington, D.C. had held that self-defense was not a recreational use of firearms. So if someone was breaking into your home in Washington and you had a shotgun, you were not allowed to unlock it and use it to defend yourself. You could use it to go to the gun range and use it recreationally, but you couldn't use it for self-defense. So Washington, D.C.'s law was essentially a ban on the use of firearms for self-defense. Justice Antonin Scalia wrote the majority opinion for the court in the District of Columbia versus Heller case, and his opinion was hailed by legal scholars as a triumph of originalism. Originalism, if you're not too familiar with it, is the theory of constitutional interpretation that says judges must decide constitutional cases by looking at how the underlying provision was originally understood by the Americans who ratified that language and put it in the Constitution. And over his more than 30 years on the Supreme Court, Scalia was a frequent and passionate advocate for the idea that judges must adhere to the original understanding of the Constitution. And indeed, in the Heller case, Justice Scalia relied heavily on founding era and early American sources to decide that the amendment was originally understood to protect an individual right, pretty much like all the other provisions of the Bill of Rights, such as the First Amendment, which protects the right of free speech and religion, and the Fourth Amendment, which protects individuals from unreasonable searches and seizures. Now, Justice Scalia's opinion for the court did suggest that some gun laws were almost certainly constitutional despite the Second Amendment, such as bans on the possession of guns by people convicted of felonies and restrictions on guns in sensitive places like schools and government buildings. Interestingly, none of the restrictions Scalia suggested were acceptable stemmed from the founding era. Bans on felons possessing firearms were first enacted in the 1930s and really swept the nation in the 1960s. This is well over a century and a half after the adoption of the Second Amendment. The founders did not bar felons from possessing firearms. Most felons were put to death, but there was no particular prohibition on possessing firearms if you were convicted of a crime. Bans on guns in schools and government buildings, sensitive places like this, those are of even more recent vintage, adopted mainly over the past 30 years. Of course, bans on guns for felons and bans on guns in sensitive places make a lot of sense, but they are modern laws that have no basis in the original understanding of the Second Amendment. Scalia's triumph of originalism turns out to really be a kind of living constitutionalism, allowing the Constitution to evolve to keep up with current values. When laws that were adopted in the mid to late 20th century shaped the meaning of the Second Amendment, it's not originalism doing the work, it's the current present day values. Now, the Heller case left many questions unclear. For instance, the court did not say whether the right to bear arms extended outside of the home, affording people the right to carry guns in public. That wasn't the issue before the court in that case. And while Scalia recognized some gun laws as constitutional, his opinion did not make clear how courts were to decide if any particular gun law was permissible under the Second Amendment. We have some laws that are allowed, some laws that are not allowed. How do we decide between them? Usually the Supreme Court articulates a test or a standard that courts are to apply to make that kind of determination. But the court has yet to do so for the Second Amendment. Nonetheless, the Heller case did spark a tremendous amount of litigation, with gun rights supporters like the NRA and others bringing court challenges to any number of gun laws. Indeed, since 2008, when the Heller case was decided, the lower federal courts have decided about 1,000 Second Amendment cases. In the vast majority of these cases, the courts have upheld the challenged gun laws. The courts have upheld laws requiring background checks for gun purchases, bans on guns in national parks, prohibitions on guns for domestic abusers. The courts have also upheld restrictions on concealed carry of firearms, bans on military-style rifles, and limits on the size of gun magazines. The widespread upholding by lower courts of gun laws in the wake of the Heller case has led some justices to complain that the lower courts are treating the Second Amendment as a second-class right. Justices Clarence Thomas, Neil Gorsuch, and Brett Kavanaugh, for instance, have all authored opinions calling on their colleagues to take more gun cases and to strengthen Second Amendment protections. Courts, these justices have suggested, should be tougher on gun laws. What would it mean if the Second Amendment were treated like a first-class right in the view of these justices? Well, presumably it would mean that some existing gun laws would be overturned. Right? If the courts aren't giving enough respect to the Second Amendment, it must be that they're upholding laws that the justices think should be invalidated. The Supreme Court has now heeded the call to take another Second Amendment case this term, And in early November, just a few weeks from now, the justices will hear arguments in a case out of New York called New York State Rifle and Pistol Association versus Bruin, known by the acronym of the gun rights group involved, NYSERPA. I know that's an odd name, but New York State Rifle and Pistol Association, NYSERPA. This case involves a Second Amendment challenge to New York's discretionary licensing law for concealed carry of firearms. Every state permits people to carry concealed weapons, but a handful of states like New York, California, and Massachusetts make it extremely hard to obtain a license to carry a firearm, which is necessary in those states in order to carry one. In states like New York, a resident must show proper cause for carrying a firearm. It's not enough to simply be afraid of crime. The applicant must have a unique and special need for self-protection that's distinguishable from the general concerns of safety of the general community. So if you're being stalked, for instance, or you carry around a large amount of cash or jewelry for your work, you may be able to get a concealed carry license. But if you're just scared of being mugged because you live in New York City, then you're not eligible. That is not a special need, a proper cause that's distinguishable from the safety concerns of every other New Yorker. The result is that very few people have permits to carry concealed firearms in New York. The New York State Rifle and Pistol Association, or again, NYSERPA, and other challengers argue that because New York's law makes it practically impossible for an ordinary resident to lawfully carry a concealed weapon, then New York's law must violate the Second Amendment. Since the Heller case, there have been numerous other challenges to these kinds of restrictions on concealed carry. Gun rights advocates have for years promoted the idea that the right to bear arms includes the right to carry a concealed firearm on the public streets. Beginning in the late 1980s, the NRA and others began pushing states to reform their concealed carry laws to make it easier for any law-abiding adult to carry a weapon. They were remarkably successful. In 1980, only 2 states allowed pretty much anyone to carry a concealed weapon. But gun rights advocates were able over the past 3 decades to persuade at least 38 additional states to loosen their permitting requirements. Today, about 40 states require either no permitting at all to carry a concealed weapon or have what is known as shall issue permitting. That is, authorities shall issue a concealed carry permit to anyone of age without a criminal record who applies. It truly is an incredible story of political activism and political success. Gun rights activists articulated a view of the right to bear arms that included the right to carry concealed firearms in public, and then mobilized and pushed to make that vision of the right to bear arms a reality. And they didn't do it through the courts, but they did it through the state legislatures, winning victories in state after state after state. Now, of course, for all their success, there still remained a few holdout states, places like New York, California, and Massachusetts, where gun rights proponents are not nearly as strong as gun safety reform advocates. And after Heller, gun rights supporters brought legal challenges to the restrictive concealed carry policies of those holdout states. Yet, in the 13 years between 2008 and just recently, the Supreme Court steadfastly refused to take any of these cases. One case after another was appealed to the High Court, but the justices turned every one of them down, refusing to rule on the question. This term, however, the court has accepted the NYSERPA case, a reflection, at least in part, of how the personnel on the court has changed. President Donald Trump added 3 new justices to the Supreme Court, and each of them have strong pro-gun records. For instance, when Justice Brett Kavanaugh was a lower court judge, he was one of only a handful of judges in the entire country to vote to strike down a ban on assault weapons. When Justice Amy Coney Barrett was a lower court judge, she voted to narrow the current lifetime ban on possession of firearms by people with felony convictions, saying the law went too far. She was a dissenter in that case. She could not find any other judge to join her, but it reflects her own views of a very expansive Second Amendment right. The three Trump justices joined three other members of the court who sided with the majority in the Heller case, Justice Thomas, Justice Alito, and Chief Justice John Roberts, to create what looks like a solid 6-3, maybe at worst a 5-4 majority in favor of more expansive Second Amendment protections. Indeed, many Supreme Court watchers believe it is inevitable that the court will do just that in the NYSERPA case this term. And that's probably correct. If I were a betting person, that's probably where I would put my money, bet the favorite. But the NYSERPA case is a challenging one, and it presents some unusual hurdles that could make it harder than some people imagine to strike down New York's law. First, there is the challenge for the originalists on the Supreme Court, who are part of that new pro-gun majority. The Heller case did not offer an extended analysis of whether the right protected by the Second Amendment extended outside of the home. Scalia did say that bear arms under the Constitution, that language, was not limited to solely a military meaning, but he suggested instead, that bear arms was used to mean to carry guns in public in case of confrontation. Since Heller was decided, however, there's been a lot of new evidence that calls into question Scalia's assumption. For example, we now have access to corpus linguistics databases of English language texts from the founding era. For instance, Brigham Young University has something called the Corpus of Founding Era American English. It's a database that has millions of words from millions of pamphlets, books, and texts from the founding era. And in that database, you can find the phrase bear arms used hundreds of times. But interestingly enough, in 93% of the references in the database, bear arms is used in a military context. There's a few cases that are unclear, but only 4% of all the references in the database to bearing arms were clearly outside of the military context. Moreover, all of the discussions of the Second Amendment in the state ratifying debates over the Bill of Rights focused on state militias, not carrying guns for personal protection, totally unassociated with militia service. And when you couple this, the corpus linguistics database material with the language in the amendment itself, which refers to a well-regulated militia, there's at least a much stronger argument today than when Heller was decided that bearing arms was originally understood solely in a military context. There's also the challenging issue of what standard or test to apply to gun regulations under the Second Amendment. As I mentioned, the court did not clarify that in the Heller case. Several justices on the Supreme Court have argued that the justices should decide the constitutionality of gun laws today by looking at the history and tradition of gun regulation over the course of American history. If a gun law challenge today is the type of gun law that has historically been in place, then it is most likely constitutional. History and tradition are indeed promising tools for interpreting the Second Amendment in many ways. The right to keep and bear arms is one of our oldest rights. It's embedded in the Second Amendment, but also importantly in state constitutional law. Every state has its own constitution, and nearly every state's constitution includes protections for the individual right to have arms. For all the controversy over the meaning of the Second Amendment, there's no dispute that these state constitutional provisions guarantee an individual right, separate and apart from militia service. And indeed, since the 1820s, gun rights advocates have invoked these state constitutional provisions in challenges to a wide variety of gun laws. And there have been plenty of laws to challenge. States have generally taken the lead on regulating guns over the course of American history, and there have been hundreds and hundreds of gun laws enacted over the years. Indeed, while some people might believe that gun restrictions are sort of a relatively new modern day phenomenon, nothing really could be further from the truth. The founding generation that adopted the Second Amendment also supported and enacted gun restrictions. Early Americans barred people thought to be a danger to the public order from possessing firearms. They barred, for example, enslaved people from possessing guns, and even prohibited guns from free blacks who otherwise enjoyed many of the same rights as citizens. The founders even disarmed law-abiding white people at times, namely loyalists. Loyalists were not traitors, by the way. We're not talking about people who were fighting for the British in the Revolution, but they were political dissenters who thought that the Revolution was a mistake, and that Americans would ultimately pay for that mistake. And it's hard to believe, maybe it's hard to believe now that anyone could oppose the American Revolution. Who could do such a thing? Well, it turns out that America back in the Revolutionary era was a little bit like America today, and almost any issue was sure to divide Americans. And there were about 40% of the white population were loyalists and thought the revolution was a mistake. And these people were subject to mandatory confiscation of their arms or laws that prohibited them from stockpiling firearms. The founders also had an early version of gun registration. They required citizens to appear at public musters with their military capable guns, where they and their weapons would be registered on public rolls. The government needed to know where those guns were in the event of war, and those guns needed to be used. And if you did not show up as part of militia service, the government would use those public rolls and registration to support confiscation of privately owned guns. The founders did confiscate privately owned guns for the war effort, coming to people's homes and taking their guns. This was known as impressment, and the gun was supposed to be eventually returned to the owner after the war. But the firearms were nevertheless taken away by the government, even if it left someone without a firearm to protect themselves against a criminal attack. The founders also had the military equivalent of an individual mandate. You know, the controversial provision that was in the Obama healthcare reform law that required people to purchase health insurance? Some people said, well, what right does the government have to force you to buy health insurance? Well, the Militia Act of 1792, adopted by obviously one of our very earliest Congresses, required that all free able-bodied men between the ages of 18 and 45 years of age to outfit themselves with a military-capable musket and ammunition, whether you wanted to or not, and even if you had to go out and buy such a gun. The founders also had laws like the one in Boston that prohibited the keeping of a loaded firearm in any building for fear that gunpowder might ignite and start a fire. So the founding fathers, they believed in the right to bear arms, but their view of the right was not sort of as a libertarian license for anyone to have any gun and take it and do with it whatever they wanted. They balanced gun rights with regulation when necessary to promote the public welfare. Gun laws, by the way, were also commonplace on the frontier in America. No time or place is thought to embody America's gun culture more than the Wild West. You know the image, the cowboys sauntering through town with 6 shooters on each hip, rifles in their hands, maybe even a little Derringer pistol concealed underneath their pant legs. You know, and through popular culture, we learn about shootouts in the Old West, like the notorious gunfight at the OK Corral, which took place in Tombstone, Arizona back in 1881. And we're sort of taught to imagine this is what life on the frontier was like. Shootouts at high noon, the bad guys running through town with their guns, and basically just a real gun culture. Yet it turns out that frontier towns back in the day had some of the most restrictive gun laws in the nation. Certainly people living or traveling through the frontier had guns. You know, if you're going out through the great wilderness where there's no police, no one to protect you, you need firearms to protect you and your family and your possessions against bandits, hostile native tribes perhaps, and also wild animals who you might need to fight for self-defense or kill for food and sustenance. But when you came into a frontier town, such as Dodge City, Kansas, or Tombstone, Arizona, for instance, city ordinances required you to check your guns with the sheriff. You'd receive a little token or claim check and use that to pick up your guns on the way out of town. Pretty much like what you might do with your coat in winter if you go to a fancy restaurant. Well, I know in Lubbock, like Los Angeles, we don't really wear coats in the winter, do we? No, not too much. Maybe for like 2 weeks a year. But when Dodge City, Kansas, the famous gunslinger town of Dodge City, was established, The very first law that was passed was a restriction on the concealed carry of firearms, later expanded to prohibit open carry of firearms too. In other words, you couldn't walk around a frontier town looking like John Wayne with guns on your hips. In some ways, we shouldn't really be surprised, right? Little towns on the edge of civilization wanted to become bigger towns filled with civilized people. They wanted to attract families and investment. But if a businessman on his way to the bank to deposit the day's earnings, there was no direct deposit back in the day, but if that businessman was likely to be shot or held up at gunpoint by an outlaw, who was going to open up a business in that town? Who was moving their family there if there were going to be shootouts that could kill their children? And these gun laws were enforced too. Research shows that the illegal carrying of a firearm was the second most common basis for arrests in frontier towns in the Wild West period, roughly 1870 to 1890. By the way, the number one, I think that's kind of surprising that that's the number two basis for an arrest, illegally carrying a firearm. The number one basis for an arrest, by the way, is not so surprising: drunk and disorderly conduct. Gun violence was also rare. Gunfights were actually pretty extraordinary. Frontier towns averaged less than 2 homicides per year. Now, granted, these towns are not big, but still, it's not like people were getting shot day and night, or there was likely to be a shootout at high noon. Turns out there really wasn't that much of a need to get out of Dodge. Indeed, the gunfight at the OK Corral itself is really a story about gun safety reform. In 1879, 2 years before the famous gunfight, the Tombstone City Council adopted a gun control law known as Ordinance Number 9, which banned the carrying of deadly weapons. The Clanton gang that was involved in the shootout was supposed to hand in their guns when they came into town, right, and get the check from the sheriff, but they refused. And Wyatt Earp and his brothers, all deputized to enforce the law, were out there that day enforcing a gun control law when the shootout happened. So there's certainly plenty of gun regulation over the course of American history that the Supreme Court can look to when using history and tradition to guide Second Amendment rulings. Yet we should also recognize some of the pitfalls of using history and tradition. One pitfall is that some gun regulations over the course of American history were racist, designed to discourage racial minorities from having guns. I already mentioned the racist gun laws adopted by the founders, but even after the Civil War, Southern states, for instance, enacted the Black Codes to restrict the freedoms of newly emancipated Blacks. And these included prohibitions on the possession of firearms. In the 1960s, when Black Power activists like the Black Panthers and Malcolm X called for African Americans to arm themselves to fight back against police abuse, Congress passed the Gun Control Act of 1968. That law was designed in part to make cheap guns less readily available in America's cities, where minorities tended to live. The racist history of gun laws, of course, should not necessarily mean that past examples of gun laws should always be irrelevant, or that gun laws are inherently racist. Many facets of the law were manipulated by the white society to keep racial minorities in a subservient status. Property laws were designed to allow racially restrictive covenants. Marriage laws prohibited interracial marriages. But the justices should nonetheless be careful of this racist history when weighing the importance of historical patterns of gun regulation, and to be sure that they don't repeat past mistakes. And this history of racism also reminds us that when we consider the laws of yesterday, we have to remember that those laws reflect the values of that era, and that those values may not be the same as ours today. Another pitfall to using history and tradition is that it does not seem to create much space for lawmakers to try innovative solutions for preventing gun violence. Consider a popular reform that has been adopted in recent years, so-called red flag laws. These are laws that permit a court to temporarily confiscate guns belonging to someone going through a crisis where they might pose a threat to themselves or to others. And this novel reform has really broken through the partisan divide over gun safety reform and has been adopted in both red states and blue states. A proposed federal law to encourage states and to finance the state's institution of red flag laws has been co-sponsored by Republican Senator Lindsey Graham, an otherwise staunch opponent of gun control. While red flag laws have unusually broad bipartisan support, there's no obvious historical precedent for them. There's no history and tradition of laws authorizing the temporary removal of guns from people who have not been convicted of any crime. Are red flag laws therefore unconstitutional? For justices who believe that only those gun laws with a historical pedigree are constitutionally sound, the answer would seem to be yes. Red flag laws are unconstitutional. Although many Supreme Court watchers believe the justices are certain to overturn New York's concealed carry restrictions in the NYSERPA case, that state's law on concealed carry does have some historical precedent that the justices will have to consider. Concealed carry bans were first enacted in the South in the early 1800s, apparently to limit dueling. New York first prohibited concealed carry in 1881, 150 years ago. New York's current style of restrictions, which limits concealed carry permits to those with a proper reason for carrying, date back to 1911, 100 years ago. Indeed, for most of the 20th century, nearly all the states severely restricted concealed carry of firearms. And paradoxically, perhaps, the NRA played a large part in making that so. The NRA was actually one of the main groups that pushed states to adopt proper cause permitting for concealed carry back in the 1920s and 1930s. Today, of course, the National Rifle Association is widely seen as a no compromises proponent of unfettered gun rights. But it wasn't always this way. For much of its existence, the NRA was a supporter of gun control. In the 1920s and 1930s, the NRA helped draft the Uniform Firearms Act. It was a model law that restricted the concealed carry of firearms on public streets. That model legislation required anyone who wanted to carry a concealed weapon to obtain a permit. And like New York in the NYSERPA case, only made those people with a proper or good reason eligible to obtain a permit. The NRA not only wrote the model law for restrictive concealed carry policies, but then endorsed these restrictions and advocated them nationwide. In the 1930s, the NRA backed and supported the first major federal gun control law, the National Firearms Act of 1934. That law restricted access to machine guns and sawed-off shotguns, the kinds of guns that have become increasingly popular in the Prohibition era among gangsters like Al Capone and desperados like Bonnie and Clyde. Carl Frederick, the NRA's president at the time, testified in Congress in support of the federal gun control law. Interestingly enough, I found in my research that when Frederick was asked in his testimony by a member of Congress if the Second Amendment created any barrier to Congress enacting this law, Frederick said, quote, "I have not given it any study from that point of view." So think about that. The president of the NRA had never even considered whether the first major federal gun control law was affected or impacted in any way by the Second Amendment to the Constitution. Now, of course, the NRA has changed a lot since then, as has America. And it wasn't until the 1960s and early 70s that the NRA began to focus on the Second Amendment. And it happened almost overnight. In the early 1970s, the leaders of the NRA hatched a plan to quit politics and move the headquarters of the organization from Washington, D.C., the heart of American politics, to Colorado Springs, where the leaders believed the new organization could refocus its energies away from politics and focus instead on hunting and shooting sports. This proposed move upset a group of hardliners among the membership. And they determined that they were going to fight back. The hardliners saw guns as valuable not because you could hunt ducks with them. They thought guns were essential for fighting back against criminals in an era of rising crime rates. And at the annual meeting of the NRA membership in 1977, the hardliners staged a coup. They used the rules of order of the organization to assert control over the agenda of the meeting, and literally overnight replaced the entire leadership of the NRA. And the new leaders who came into power recommitted the NRA to political activism and opposition to gun safety reform. One of the primary goals of this new leadership was to expand the right to carry a firearm in public. They set out, in other words, to overturn the very same laws restricting concealed carry that the NRA itself had written and promoted back in the 1920s and 30s. As I noted earlier, these gun rights activists were tremendously successful in securing legislation at the state level, allowing people to easily obtain a permit or to eliminate the permit requirement entirely. Today, New York's concealed carry law is an outlier. And while I've identified a number of reasons to believe that the outcome of the NYSERPA case is far from guaranteed, I would still be somewhat surprised if the court upholds New York's law. For all the discussion of originalism and historical traditions, judges on both sides of the aisle, or maybe I should say both sides of the bench, tend to view legal issues through their own ideological or philosophical lenses. Their views have been shaped by the dynamics of their own era and the vision of the Constitution articulated by the NRA and so many other Americans over the past 40 years. That's why it seems to me most likely that the Supreme Court will ultimately strike down New York's restrictive permitting law and declare that the Second Amendment guarantees a right to carry guns in public, even without some special reason. But once again, we may find that the originalists on the Supreme Court are departing from true originalism to embrace a living constitution, interpreting the Second Amendment to correspond to a modern vision of gun rights, rather than truly being guided by the founders. Well, what would be the impact of such a broad ruling in the NYSERPA case? Well, in one sense, I think the impact would be small. Today, the type of restrictions in place in New York are only still in effect in a handful of states. So the number of states impacted would not be very large. In another sense, however, the impact would be quite significant. Cities like New York, Los Angeles, Washington, D.C., San Francisco, Boston, they would all see huge increases in the number of guns being lawfully carried on the public streets. In Los Angeles County, for example, there are today 10 million residents, but only about 400 ordinary civilians who have concealed carry permits. In states that have repealed proper cause permitting and allowed nearly any law-abiding person to carry a firearm, approximately 3 to 5% of the total population obtains a permit. Well, if 3 to 5% of Los Angeles County residents obtain a concealed carry permit, well, then the number of people legally carrying guns on the streets would skyrocket from 400 to something like 400,000. Now, it's not entirely clear exactly what impact this would have on gun violence. There are, of course, many other big cities in America that allow just about anyone to carry a concealed firearm, including Dallas and Atlanta, Phoenix, and Philadelphia. Among social scientists and criminologists, there is wide debate about the effect of lifting concealed carry restrictions. You may have heard the refrain, more guns, less crime. Well, that comes from the work of a scholar by the name of John Lott, who used a complicated statistical model to show that removing restrictions on concealed carry leads to decreases in violent crime. More guns, less crime. Other academics disagree, however. Stanford's John Donahue has used a similarly complicated statistical analysis and shown that removing these restrictions on concealed carry has led to increases in violent crime. The data are hard to decipher and to rely upon, but we may have more states to study very soon. Another potential implication of the NYSERPA case is how it will impact other gun laws. If it's correct that the court has a new pro-gun majority, then we might well see the Second Amendment's protections expanded in other ways, not just to allow guns on the streets, but maybe to call into question other kinds of gun restrictions too. So which laws are most likely to be questioned in the coming years? Well, I think it's unlikely that the justices will overturn too many federal gun laws, such as the ban on felons possessing firearms or background checks for gun sales conducted by a federally licensed dealer. But I do think that some of the laws recently enacted in several states, such as the bans on military-style rifles and high-capacity magazines, are indeed vulnerable. These very laws are at the top of the gun safety reform agenda. But just as that movement is gaining political strength and the prospects for enacting such laws have improved, the Supreme Court appears poised to be a barrier to such reforms. America, it seems, is entering a new chapter in the gun debate, and it's one in which the gun safety reform movement is stronger than ever, invigorated by new money, grassroots support, and the never-ending stream of mass shootings. Yet this new chapter is also one in which support for expansive gun rights has more support among the justices of the Supreme Court than ever before. And it may be that it's the voters on the Supreme Court, that is to say the justices, who are the ones who will have the final word. We should have a better sense of how this will all turn out in the spring of next year, when the court's decision in the NYSERPA case is handed down. Thank you.
Wonderful. Thank you, Professor Winkler. I learned a lot there about gun laws that I had no idea about. And it does seem like this is a particularly, this is a turning point in history of where we're going to go. So that's fascinating. I see that we have a couple of questions in the Q&A. So I'll ask the first one. At what point, if any, does the negative impact of lax gun laws on public health become a consideration in determining gun laws?
Well, interestingly enough, that's one of the issues that will really be debated by the Supreme Court in the NYSERPA case and in the cases to come after that. Generally, we say in American constitutional law that no rights are absolute, right? You have a right to free speech, but it's not an absolute right. And if the government has sufficiently good reasons, the government can stop you from speaking. So the old example is you can't falsely shout fire in a crowded theater. Why not? Because it has public health concerns, right? It will lead to a stampede and people will be injured. And obviously, if there's a real fire, you can shout fire, but you can't falsely shout fire and cause this commotion because of the public health dangers. So we usually say that rights are not absolute and that when the government has sufficiently strong reasons, the government can limit the exercise of a constitutional right. However, there are several justices on the Supreme Court who are promoting this history and tradition approach to the Second Amendment. And they argue that it's not up to judges or legislatures to weigh public policy concerns versus the right to bear arms. That people have a right to bear arms and they have the right that was as it was originally understood. And it doesn't matter if that leads to bad policy outcomes. It doesn't matter if that leads to public health problems or more murders or less murders. They say it doesn't matter because the right has already been put into the Constitution and determined, and that judges should not be empowered to pick and choose among the gun laws they think are good enough. So I think this is a real question. It's the public health problems that come from lax gun laws, and we do have a lot of guns in America. Right, there's about over 400 million guns in America. We have mass shootings. We have suicide, which is the most common form of gun violence. And while those are the things that really motivate gun safety reform advocates to be more active and to push for new reforms, it's precisely those issues that some of the justices on the Supreme Court say they don't want to have to consider, and they don't think it's appropriate to consider. So it really remains to be seen about whether those public health concerns provide any sort of reason or persuasive power with those justices to uphold at least some gun laws.
Thank you. Okay, so I'll go to the next one. A question about Scalia's originalism. How do legal scholars feel about originalism? Jefferson famously said that he expected the Constitution to be reframed whenever necessary. Maybe he said every 19 years. And is the whole concept of originalism untenable or cynically performative?
What a great question. So I'd say that legal scholars, how do they feel about originalism? Well, probably like in America, there's on most issues, big divides about how that. I think probably the vast majority of constitutional law scholars do not believe that originalism is doing the work that originalists claim. One reason why Scalia loved originalism, he said, is because it takes the judge out of the equation. The judge can't impose his or her or their own values on the Constitution. They have to stick with their historical understanding of that right as it was understood when it was adopted. And so he thinks that keeps judges from, shaping the law to fit their own biases. But a lot of legal scholars just believe that that's performative, that it's not actually the case, that Justice Scalia was not an originalist in a lot of decisions. And like I made the point about the Heller case, it may be less a matter of originalism and more a matter of living constitutionalism, where he was drawing the lines with regards to the Second Amendment. And so there's certainly plenty of people who believe that originalism is really performative. It's something that judges do so that they can claim that they are sticking with the Constitution and not imposing their own values on the text. But we should all be pretty clear that, people can't escape their own philosophical and ideological lenses that are created by a culture and a society in which we are born and raised. And that's a very, very different culture from the one that existed in 1791 when the Second Amendment of the Constitution was finally ratified. So I do think that originalism has plenty of supporters among legal academics. One important thing I should just note in closing on originalism is that regardless of what legal scholars think about originalism, virtually everyone who's going to the Supreme Court today is thinking about how to make a good, strong originalist argument in support of their case. Because I think originalism is now the dominant philosophy of constitutional interpretation on the Supreme Court. And in the lower federal courts, a lot too. President Trump appointed a lot of judges to the federal courts, many more than his predecessors had in a single 4-year term. Including 3 Supreme Court justices, and many of them were vetted by Senator McConnell and the Federalist Society, in part to see who subscribed to this vision of originalism, and only putting people on the bench who they had reason to believe were originalists. So if you're a lawyer practicing in the courts today, whether you believe in originalism or not, you better be ready to marshal originalist arguments if you want to win in the Supreme Court today.
What implications, if any, will follow from the fact that Justice Scalia's Heller opinion allowed that a variety of gun laws were permissible only to obtain Justice Kennedy's 5th vote?
Yeah, that's a great point, right? So, this question sort of comes around like in the Heller court. I mentioned earlier that the Heller court said that the Second Amendment protected an individual right to bear arms, but also said that a variety of kinds of gun control laws, like bans on felons possessing firearms or bans on guns in sensitive places, were still constitutionally permissible. And some people were surprised by that because that's obviously some of the most unoriginalist parts of his opinion. And the speculation that it's been confirmed here and there by clerks who were working at the Supreme Court at the time, but the speculation was and has been that Justice Scalia added that language saying that most gun control laws are still constitutionally permissible in order to secure the 5th vote he needed to have a majority, the vote of Anthony Kennedy. Of course, Anthony Kennedy is no longer on the Supreme Court. He was replaced by Brett Kavanaugh. And so he is no longer someone who the justices have to appeal to secure his vote. And it seems unlikely that Brett Kavanaugh, the person who replaced Justice Kennedy, has Justice Kennedy's hesitations about expanding gun rights. As I mentioned, Justice Kavanaugh, when he was a lower court judge, voted in a very important case out of Washington, D.C., his vote was a dissenting vote in that case, but his vote was to strike down Washington, D.C.'s ban on military-style rifles. So I don't think he really feels the same trepidation about the Second Amendment that Justice Kennedy might have. So I don't think there's really the same need to try to appeal to that swing voter. Remember, too, that because the majority is now 6-3, maybe even 5-4, maybe if Chief Justice John Roberts doesn't want to go along with the majority, that's possible. But then you still have 5-4. You don't have any swing justices who you need to get on board by watering down the ruling. The 5 justices in the majority would be Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. All have pretty strong opinions they've written in favor of expansive Second Amendment rights and serious limitations on gun safety reform.
Well, I'm going to use moderator's privilege and combine 2 questions, both on originalism. So first, on originalism and the Second Amendment, has any Supreme Court opinion ever acknowledged the difference between a musket and an AR-15? Historical materialism is a thing. And didn't Scalia also ditch originalism in Bush v. Gore and Citizens United?
Yeah, no, great question. Let me write this down because I want to make sure I get back to Citizens United and Bush v. Gore. No, so the court has not really addressed the differences between guns of the 1790s and guns today. The court does say in the Heller case that it would be an absurd argument to say that only those guns that were in existence in the 1790s or 1780s were protected by the Constitution. And I think that's got to be right, right? Whatever you think about the Second Amendment, that's got to be right as a matter of constitutional interpretation, that the principles embedded in the constitutional text have to be kept up to date with technology, right? Rather than say values, right? But technology. So the First Amendment, obviously it'd be bizarre today to say that the First Amendment protects your freedom of speech, but only to the extent that you use a printing press. And a printing press of the sort that they used back in 1791, right, where you had to put the letters individually, then you stamp down the paste, and then you put it through the, right. Obviously, we have the internet, and for the First Amendment to be meaningful, that freedom of speech to be meaningful, obviously it has to keep up with changes in technology. And so I think it's fair to say that the court, even that if you believe the Second Amendment protects an individual right to bear arms, you would not therefore believe that that right to bear arms was limited to those existing guns in the 1790s. But of course, the technology is very different. The technology of the internet is very different from the technology of printing press. And so rights, even an originalist just like Justice Scalia will generally think that technological changes can be addressed within the context of a constitutional right. And with regards to Bush v. Gore and Citizens United, the question was, does Justice Scalia stick to originalism there? There has been plenty written on Justice Scalia and whether he was truly an originalist or just a fair weather originalist. I think a case like Citizens United, which held that corporations have the same free speech rights as ordinary individuals, seems to me a pretty significant departure from originalism. There is no evidence at all that when the framers were writing the Constitution, they were trying to protect business corporations. Business corporations were few and far between in the founding era. There were some, but they weren't like today where they completely dominate the economy. And so the whole idea that corporations would have constitutional rights is something that doesn't seem to have much grounding in the original understanding of the Constitution. By the way, if you're interested in Citizens United and the question of how corporations became people, I actually wrote a book on that. So it's called We the Corporations, How American Businesses Won Their Civil Rights, published in 2018. And it looks at that history of corporations trying to gain constitutional rights. So that Citizens United is one of a number of decisions where Justice Scalia departed from originalism. And perhaps Justice Scalia can be criticized for that, for not being as consistent as he claimed a really good judge should be.
Sorry. So even from an originalist perspective, acknowledging 18th through 19th century concealed carry bans, shouldn't New York's May issue permitting regime be struck down because New York also bans any type of open carry? Doesn't this totally deny the individual right to possess and carry weapons in case of confrontation established in Heller?
So first of all, Heller didn't establish the individual right to possess and carry weapons because carry weapons, that issue was not before the court. The only issue in the Heller case was a right to have a handgun in your home for personal protection and the right to keep your shotgun unlocked. The court does discuss the possibility that there is a right to carry guns outside in the streets. It's known that that part of the decision is considered dicta, right? It wasn't, that issue wasn't before the court. It wasn't briefed by the court. And so it's not clear that that's what it held. Nonetheless, I do think that there is likely to be 5 or 6 justices on the Supreme Court that do believe that the Second Amendment protects a right to carry a firearm in case of confrontation on the streets. And then the question is, well, should we not nonetheless strike down New York's law because they don't allow anyone to carry a gun either openly or concealed? You hear this argument a lot in the gun rights field. There were a couple of state constitutional law cases in the around between 1830 and 1870 that said that a state could not limit concealed carry of firearms unless it allowed open carry of firearms. But for every state court reading a state constitution to require open or concealed carry, one or the other, there's an equal number of state courts that held that you could ban both forms of carry or require a permit that restricts who and when and how firearms can be carried in the public streets. So it's not necessarily the case that you have to have either open or concealed carry to carry on the streets. But that may be the case after the NYSERPA case, right? I think that's one way that the court might go. The court might go, well, you can completely ban concealed carry, but then you have to allow open carry on the streets. And query whether we might see in some states that have very strong gun control movements, like California or New York, whether they might choose to have open carry instead of concealed carry. Now, you may think that's absurd, but if you allow open carry, at least gives everyone around you the ability to know that you're carrying a firearm. And if you go into a Starbucks and you're carrying a firearm and people don't want to be in a Starbucks with someone who's carrying a firearm, well, if you have to openly carry the firearm, then people would at least know it. Starbucks would at least know it and could ask you to leave if they don't want to serve someone who's carrying a firearm. If you're carrying a concealed firearm, you have no idea. People around you have no idea you're carrying a firearm. And as a result, I think these states might have a lot fewer people openly carrying than they'll have if they allow concealed carry. So I don't really think that states are going to adopt open carry instead of concealed carry bans in the wake of the NYSERPA case, but it's an interesting thought experiment to think about. If you're a state that wants to restrict the number of guns on the streets, what's the best way to do it once the court has said you have to allow either open or concealed carry? It'd be interesting to see how some states address that issue in the coming years.
What is the effect of having a Supreme Court that is deciding the law in a way that the majority of the population disagrees with, both in gun rights and on the abortion issues discussed yesterday? Would it result in a loss of prestige for the court?
Well, that's a great question. And I think we are sort of headed in that direction where we're going to see an increasingly large divide between public opinion on some major constitutional issues and Supreme Court doctrine, that the court's moving in a different direction than public opinion on a lot of these issues. What effects that going to have? Well, can't say I know exactly what's going to have. We do know that there has already been a movement to reform the Supreme Court, to adopt, say, significant reform, adding justices to the court or limiting the term of service for Supreme Court justices. In fact, I think I just saw today when I woke up, there was news that President Joe Biden, who's empowered or impaneled a commission to look at Supreme Court reform, is expected to have a draft version of its report, maybe out today, maybe out tomorrow, but coming soon. And so we might get a better sense of whether there's any political momentum behind any kind of significant Supreme Court reform. There have been, of course, times in the past where the court has departed pretty significantly from public opinion, and in the past we've seen that that leads to some kind of political backlash. It does lead to people mobilizing and trying to fight the Supreme Court. Roe versus Wade is a good example. We mentioned that yesterday in our discussion then, but we can talk about it here too. Heller was very different from Roe versus Wade. Roe versus Wade sparked a political backlash by people who were upset that the court had recognized this right. But Heller did not spark the same kind of backlash, right? There hasn't been a backlash. We have seen a growing gun safety reform movement, but it's not seeking to overturn Heller. You don't hear a lot of discussions about Heller must be overturned. You might hear some, I'm not saying you don't hear any, but it's certainly not of the kind of power that the anti-Roe movement had. And so it's certainly possible that the court's decisions this term in abortion, if they overturn Roe versus Wade, force New York and California to allow guns on the streets, and some of the other big high-profile issues they have before them, such as possibly deciding the constitutionality of affirmative action. These things could lead to some kind of political mobilization and backlash against the court. That will, if not result in Supreme Court reform, could result in the election of people to public office, federal office in particular, the Senate and the presidency, who will support a different vision of the Constitution.
So I see some activity in the chat too about court packing and FDR's proposal to try and get the Supreme Court to pass the New Deal, or I guess not to interfere with the New Deal. I guess that's a better way to put it. What is the status of laws prohibiting physicians from inquiring about gun possession?
What is this? So we've seen a few states that have passed laws that have prohibited doctors from asking their patients about whether they possess firearms. Doctors will sometimes ask someone if they possess firearms. I will say I live in California most of my life. No doctor's ever asked me if I own any firearms. I don't think this is a common question that's asked of people who are of sound mind and of sound health. I don't think that that's a question most doctors find much interest in, right? I don't think that that's going to help them much. I might imagine doctors asking that question more frequently if you're dealing with someone who is aged and who you're worried might be having some competency issues. Maybe if someone's having some issues that might lead a doctor to be concerned about self-harm or suicide, I can imagine doctors being concerned. And I could imagine doctors being concerned for parents if they have a toddler or a young child at home who could get their hands on guns. I could imagine some situations in which doctors would genuinely ask about a firearm in the home for public health or for the patient's health reasons and the health reasons of the patient's family. So I think that's why it happens. Maybe there's some doctors out there, real lib doctors, who are like, berating their patients for possessing firearms. But I get the feeling that that's not a great practice if you want to keep your clients, keep your patients, right? It's a good way to alienate patients if you're asking someone who's a gun rights supporter, do you have guns? You shouldn't have guns in your home for no reason. So there are some states that have passed laws that restrict doctors from giving this advice. It raises actually an interesting First Amendment issue about the doctor's First Amendment speech rights. Like, don't the doctors have the right to speak with their patients the way they think is appropriate to speak with patients? But at the same time, we do sometimes limit and restrict and require doctors and healthcare providers to provide information to patients or restrict what they can say to patients in some, at least extreme cases, as a result of trying to protect and promote public health. So, so we do have some of these laws on the books, but not too many.
So I see in the chat, seems to be a question, yeah, if they're treated for depression. Yeah, because we know, I think you mentioned earlier, Professor Winkler, that the number one sort of active violence done with guns is suicide, right? Not homicide.
That's right. Suicide makes up a majority of gun deaths every single year. Back, no question about 60%, in fact. So it's kind of overwhelming. And it's interesting because I think that the gun debate is really centered today in America around the idea of mass shootings, right? Mass shootings seem to be the news event that spurs more political activism, more political mobilization around this issue. But mass shootings are really few and far between. Now, that's not to say we don't have too many of them. We have way too many of them, no doubt about that. We know it's not like it's a good thing that we should have more of. But they also make up a very, very, very small fraction of gun deaths every year. We're talking about, less than 1%, less than 2% in any big significant year. In fact, I don't know of any year that's ever made it more than 1%. And so we're talking about a very, very small slice of the gun violence problem. And yet that's what dominates our political discussions. That's what people are always asking, what can we do to stop mass shootings? But what we're not thinking about is what can we do to stop suicide? Right? What can we do to stop people from killing themselves with firearms? Now, you may say there's nothing you can do. Someone who wants to commit suicide or kill themselves can do that and nothing can stop them. But again, like the public health data just doesn't support that conclusion, right? It turns out that most people who try to commit suicide are terrible at it and are unsuccessful at it. And if you try to commit suicide by jumping off a building or by taking pills or by slitting your wrists or by hanging yourself, your success rate is very low. And you probably won't succeed in taking your own life. If you put a gun to your head and pull the trigger, however, your rate of success goes up to about 99%. So if in countries that don't have access, civilians don't have access to guns, attempted suicide rates are often similar to the United States, but the successful completion of suicide rates are much lower because it's just harder to commit suicide and do it effectively without a firearm. It can be done, but again, it's just less common. So if we want to talk about gun reform, maybe we should be talking less about what's going to stop the next mass shooting, which is probably impossible to stop in a country with a lot of guns, and we have lots of guns, and try to think about what we can do to lower the death toll from guns every single year that occurs from self-harm.
Sure. And we know that also with gender, right? Women are much less likely to use guns than men. And so we know that men and women seem to attempt at about the same rate, but men are just more likely to be successful because they use guns as opposed to a method that you can have a second thought with, like overdose, right? Okay, I think we have our last question about a philological analysis of the phrase bear arms. Does anyone on the NRA side of the issue ever admit analysis of the phrase in a well-regulated militia? Has the Supreme Court mentioned that phrase in any opinions?
So yes, of course, that the Supreme Court has addressed the well-regulated militia language in the Second Amendment. That's obviously an important issue. The NRA has often tried to avoid the issue for the most part. I remember that the NRA's headquarters in Washington, D.C., for a long time, they've since moved, but for a long time, the headquarters in Washington, D.C., it's now in Virginia across the Potomac. But when it was in Washington, D.C., they had etched into the wall above the main entrance the words, "The right of the people to keep and bear arms shall not be infringed," conveniently omitting the first clause of the Second Amendment that talks about a well-regulated militia being necessary to the security of a free state. So the NRA has kind of tried to avoid that militia language for a long time because they didn't want to think of the right as a militia-based right. Justice Scalia Justice Scalia addressed this issue, and what Justice Scalia said was, I think along the lines of what I said in my talk, which was that the founders really were thinking about the militia for the most part. That's what was motivating them to protect the right to bear arms, was the idea of protecting the militias. What Scalia says is that the language in the Second Amendment that refers to a well-regulated militia is not in opposition to the individual right to bear arms, but rather the militia, which was made up of common citizens, those are the people who need to have guns in their own home so that they can serve adequately in the militia or otherwise use firearms. So Justice Scalia said the militia was the primary reason, but not the only reason for protecting the right to keep and bear arms, and that there are broader concerns about self-defense and whatnot that remain strong. Interestingly, of course, today, the militia has no meaning and has no usefulness for an individual right to possess firearms, right? We don't think about national defense in terms of state militias. We think of it, we do have a standing army, unlike the framers. And I think the last thing Americans would really want to rely upon if we got into, if say a foreign country tried to invade our shores, is relying on ordinary people using their ordinary guns to fight back without outside of the context of a militia or of a standing army.
Wonderful. Well, thank you all to the participants for your wonderful questions. And I think that will end it for today. We'd like to thank you, Professor Winkler, for all the work and interesting intellectual exercise that you provided for us over the last day or two. We really appreciate it.
Thank you so much. It's been such a pleasure to be with you. Like I say, I only wish we were doing it in person, and I hope I get the chance to come visit Lubbock and visit Texas Tech before too long.
Awesome. Thank you. And thank you to all the panelists, all the participants for coming. And I will be putting this up on our YouTube channel now. Bye.